The Federal Mine Safety and Health Act of 1977 was established by Congress to protect our nation's most valuable resource, you, the miner. The act is a law. It lists the penalties for mine operators and agents charged with having unsafe and unhealthy working conditions at their mines. The act established the Mine Safety and Health Administration as the agency charged with enforcement of the act, and set the ground rules for operators that mine stone, sand and gravel, coal, and other minerals. The act gives the Mine Safety and Health Administration authority to propose safety and health regulations, which after an extensive review process are incorporated into Title 30, Code of the Federal Regulations. Title 30 contains specific rules and standards that operators and miners must comply with to prevent injury and illness on mine property. The act gives miners and their representatives a right to participate in the rule-making process. You may comment on, object to, or challenge a proposed standard or regulation. It was Congress's intent for miners and operators to anticipate, identify, and prevent all existing hazards, and then put a system in place that would promptly identify and correct any new unsafe and unhealthful working conditions and practices. Essentially, Congress felt you and your employer have a joint responsibility for safety and health. Each employee is responsible for his or her own personal safety. This includes performing work in a safe manner, ensuring the workplace is free of hazards, and making sure assigned equipment is in safe operating condition. Your training and experience will help you to identify hazards. If you find a hazard and are unable to correct the hazard immediately, it may be necessary to warn your co-workers, and it is your responsibility to report the hazard to your supervisor. If it is an imminent danger, exposed persons must be removed from the hazard immediately. If your company's safety and health reporting system is working properly, this should take care of the problem. If not, the Mine Act protects your right to report safety and health hazards to the Mine Safety and Health Administration at any time. Communicating effectively is the key to a safe and healthy workplace, so make it a point to discuss your concerns with your supervisor or manager. Your on-site supervisor is the person who's required by the Mine Safety and Health Act to take corrective action. It may be necessary for you and your supervisor to talk with others to find or identify the best course of action to take. Good communication between workers and management can reduce confusion and greatly aid in the elimination of hazards. That brings us to the responsibility of managers and supervisors, who are held to a higher standard because they control the resources, give work instructions, set priorities, and direct work efforts. They also determine if the workplace is safe and healthy. Managers and supervisors are responsible for ensuring that employees perform their jobs correctly and for making sure every hazard is corrected promptly. If your supervisor is unaware of a safety or health concern, it's your responsibility to tell him or her about it. Remember, an effective safety and health program requires your participation. At least twice a year, each surface mine will be inspected by a safety and health inspector from the Mine Safety and Health Administration. Underground mines will be inspected at least 4 times a year. Seasonal operations may receive fewer inspections. The Act states a miner's representative has the right to accompany the inspector with no loss of pay. If there is no representative at your mine or one is unavailable, a miner may be selected to travel with the inspector. Should a representative, for whatever reason, not travel with the inspector will make an effort to talk to the workforce about health and safety matters. While you should have already discussed any safety or health concerns with your supervisor, you have a right to discuss uncorrected concerns with a Mine Safety and Health Administration inspector as well. The Mine Safety and Health Administration may also investigate a complaint. It is your right to request an inspection when you have reason to believe that an imminent danger or violation of the Act or a safety or health hazard exists. You are protected against retaliation for exercising this or any other right under the Mine Act. Congress made a point to give miners and their representatives protection against discrimination. You cannot be fired, transferred to a lower-paying job, refused employment, harassed, or otherwise lose job benefits as a result of exercising your rights under the Act. If a Mine Safety and Health Administration inspector finds a violation of one of the safety or health standards, he will write a citation or order, which is given to the company. A copy of the citation or order must be made available to miners and their representatives. You have the right to request a conference with the Mine Safety and Health Administration, and if you so desire, can challenge or contest the issuance, modification, or termination of any order. You may also contest the time allowed to abate the order. If a Mine Safety and Health Administration inspector finds something that is so serious he thinks it might kill or injure someone before it can be corrected, he or she will issue a withdrawal order to stop the affected operations. If you are working in the affected area, you will be told about it. You will stop work, and you will leave the area. All workers idled by the withdrawal order are eligible for regular pay for the remainder of the shift. If the withdrawal order continues due to a failure by the company to comply with or correct a safety and health standard, you are paid for the lost time at your regular rate for the time idled, or for 1 week, whichever is lesser. If you or any employee feel you've been denied pay because an operation had to shut down to correct a hazard, you have a right to file a complaint with the Federal Mine Safety and Health Review Commission. It is your right and responsibility to participate in and observe exposure studies involving noise, dust, and other toxic materials or harmful agents. You also have the right to access your exposure records even though the company informs you about sampling results and what is being done to correct situations involving overexposure. A mine operator or independent contractor working on a mine site is required to provide training which complies with the standards covered in either Part 46 or Part 48 of Title 30 of the Code of Federal Regulations. This training must teach you how to recognize hazards and show you how to perform your job correctly, safely, and efficiently. It is your responsibility to perform your tasks in accordance with your training. 5 types of training are required. These include new inexperienced miner training, new experienced miner training, new task training, annual refresher training, and site-specific hazard awareness training. For companies that must comply with the Part 48 standards, which apply to surface coal, metal, and gypsum mines, and all underground mines, a copy of the company's training plan must be provided to the miner's representative. If there is no representative, a copy of the training plan must be posted on the mine bulletin board at least 2 weeks prior to submittal to the Mine Safety and Health Administration for approval. Companies that are regulated by the Part 46 standards, which apply to most surface non-metal mines, are not required to submit their training plans for approval if they include all the elements required by the standard for each of the 5 types of training: new and experienced miner training, newly hired experienced miner training, annual refresher training, new task training, and site-specific hazard awareness training. If a Part 46 training plan does not contain all the elements required in the standard, it must be submitted to the Mine Safety and Health Administration for approval. The training plan must be posted on the mine bulletin board at least 2 weeks prior to training taking place. You have a right to receive all required MSHA training, and if an inspector finds that you have not, you will be withdrawn from the work area until you are trained. You cannot be fired, discriminated against, or suffer loss of pay during the period the required training is being provided. This videotape has briefly highlighted some of your rights and responsibilities as a miner. Also available is a guide to miners' rights and responsibilities under the Federal Mine Safety and Health Act, which further summarizes your rights and responsibilities. If you have questions regarding what is contained in this videotape or the guide, do not hesitate in asking your trainer or instructor.